right, we are live. Everything looks good here, and everything looks good there. So let's get to it. Josh Gablin here, copyright attorney out of Illinois. We're going to be looking at a new copyright infringement generative AI lawsuit that was filed last week. We're in the U.S. District Court in the Northern District of California, San Francisco Division. We have Christopher Farnsworth individually and on behalf of others similarly situated as the plaintiff versus Meta Platforms, Inc., which we, of course, know from Facebook fame and now beyond. They're trying to do a class action complaint here again. So this is always interesting to see. We've got a lot of these going on right now. I'm getting this information again from, like the previous video, from ChatGPT is Eating the World. That is a website run by Edward Lee. He is one of the leading people talking about this right now. And so without further ado, let's jump into this here. A much shorter complaint this time. The nature of the action. Meta stole hundreds of thousands of pirated copyrighted books to build a commercial product called a large language model, LLM. The United States Constitution recognizes the fundamental principle that copyright holders are entitled to exclusive rights in their works in order to incentivize further creation. Meta ignored this basic principle and the federal law embodying it by stealing and exploiting copyright-protected books for profit. Very straightforward. Plaintiff Chris Farnsworth is a best-selling fiction author. He brings this class action under the Copyright Act to redress the harm Meta's infringement caused to him and other authors. Meta exploited plaintiff's works without authorization, made illicit copies of them, and then fed those copies to its LLM. Meta did this to enhance the quality of its LLM's language output and ultimately to have a more desirable and profitable LLM product to compete in the AI arms race that has developed over the last few years. So this is somewhat typical of the generative AI claims that we've been looking at in these other cases. I think, like I said, 32 of these filed so far for copyright infringement. Let's see here. Meta calls its set of LLMs Llama. Like other LLMs, Llama is an AI software program designed to emit convincingly naturalistic text outputs in response to user prompts. The quality of Llama's output is determined by the quality of the data it is fed. Meta knew that the more high-quality long-form text it fed to Llama, the better Llama would perform commercially. In this way, Llama is what it ingests. By willfully including unauthorized and pirated copies of the plaintiff's copyrighted literary works in its development, pre-training, and training data, Meta exploited authors' literary talents without consent or compensation of any kind. This is kind of the opposite of the Lehrman voice actor case that we reviewed last week, was also recently filed, in that they are alleging a very specific thing here. It seems like they're just saying copyright infringement, whereas in that we read last week a 60-page complaint, of which copyright infringement was only a couple of those claims here. So this seems to be very poignant. Let's look at the factual allegations here. Meta's development and commercialization of Llama, right. Founded in 2004 as a social media company, then called the Facebook Inc., Meta has grown and diversified its technology services rapidly over the last 20 years. Presently, Meta has a market capitalization of over $1.4 trillion and is among the 10 most valuable companies in the world. Meta makes billions of dollars selling advertising and services across its flagship platforms like Facebook, Instagram, and WhatsApp. Following the sensational consumer response to OpenAI's release of ChatGPT in November of 2022, many of the world's largest technology companies accelerated their research and development of commercial LLMs. ChatGPT was powered by an LLM capable of generating uncannily human-like responses to people's queries. In February 2022, Meta developed and released a collection of foundational LLMs and called it Llama. You can see get the name here, LLAMA. As part of its commercial generative AI development initiative. These LLMs were later renamed Llama 1. Meta initially released Llama 1 for non-commercial research uses. Less than 5 months later, in July of 2023, Meta released Llama 2, this time available under a permissive commercial license. By September 27th, 2023, Meta reported that the users had downloaded over 30 million copies of llama-based models. And we have their citations here are to the Meta website for those claims. On April 18th, 2024, Meta released Llama 3, which it built on the foundation of Llama 1 and 2. Upon its commercial release, Meta touted Llama 3 as powering its new consumer service, Meta AI, one of the world's leading AI assistants. Meta admittedly is using its LLMs to enhance its current commercial products, and, on information and belief, Meta is working on a premium paid subscription version of its AI assistant service powered by Llama 3. No citation for this last one here. We do see the on information and belief, so that tells you what they have so far and hints at what they're going to want to ask for. Meta developed its commercial AI model using stolen copyrighted material. So section A, the large language models and the training process here. At issue is a species of AI models called large language models, or LLMs. LLMs are designed to mimic human use of language. LLMs are able to simulate patterns of human language by processing input text as prompts and generating output text in response to these prompts on a predictive basis, that is, determining what word follows what. At a high level, LLMs are algorithms designed to distill mathematically the relationships between words and written works through a process called training. LLMs achieve this goal by ingesting massive amounts of training material such as books, breaking down input text into smaller pieces, words or portions of words, called tokens, then translating those pieces into vectors, or a sequence of numbers that is used to identify the token within a series of algorithms. Those vectors help place each token in a probabilistic context, identifying other tokens closely associated with the word. As described by industry-leading generative AI development company OpenAI in comments to the Copyright Office, the process begins by breaking down text into roughly word-length tokens, which are converted to numbers. The model then calculates each token's proximity to other tokens in the training data, essentially how near one word appears in relation to any other word. These relationships between words reveal which words have similar meanings and functions. As the model trains by digesting more and more written works, the algorithms which distill the relationship between various tokens changes with it. A model takes text inputs in the form of an incomplete phrase or passage and attempts to complete the phrase, essentially a fill-in-the-blank quiz. A model compares its predicted phrase completion with the actual correct answer and then adjusts its internal algorithms to learn from its mistakes and minimize the difference between any given text input and the correct text input. A model then repeats this same cycle millions, possibly billions of times across the entire corpus of training materials, adjusting its algorithms each time to reflect the text input from the corpus. This is known as the pre-training process, which is the foundation of creating a base LLM model, which can be fine-tuned later to achieve more specific results. The pre-training process fundamentally enables a model to process prompts and generate text output that mimics human language. It does so by exposing a model to a wide range of texts and using algorithms to predict the next word in text. By repeating this process, a model develops fluency in style, syntax, and expression of ideas, largely by digesting and processing the protected expression contained in the material used for training. The LLM mines the expression contained in the training corpus, adjusting its algorithms such that it can mimic the ordering of words, style, syntax, and presentation of facts, concepts, and themes. In a literal sense, a model is what it ingests. Without training on material, there is no LLM. The quality and quantity of the training corpus is critical to the quality of the resulting model. As one researcher put it, large language model behavior is not determined by architecture, hyperparameters, or optimizer choices. That is, technical features set during model training. It's determined by your data set and nothing else. Everything else is a means to an end in efficiently delivering compute to approximating that data set. Conversely, if the LLM's training materials are of poor quality, the output, the end product, will also be of poor quality. Okay, so they're giving us a lot of background here, to the court rather, and we kind of understand that why courts are not known for their technological expertise, so it makes sense that they would want to give the court an understanding of what a large language model is. They're going with OpenAI's definition, if you would call it that, the description given by OpenAI, and using that as a basis as Meta's competitor here so that they don't have Meta's actual things to base it on here. It'll be harder for Meta to come back and say that their competitor means something different, right, than that Meta actually means something different. Any LLM training process, including Meta's training of Llama, involves creating multiple copies of the training text, which often include a vast number of written works in their entirety. As the USPTO has observed, large language training, almost by definition, involves the reproduction of entire works or substantial portions thereof. USPTO meaning U.S. Patent and Trademark Office there. Alright, Meta copied a massive trove of pirated books to train its Llama models. So, in public disclosures, Meta admitted that it made unauthorized copies and willfully reproduced copies of nearly 200,000 pirated copyrighted books to advance its commercial AI training and development projects. Since those disclosures, Meta has become less forthright about its AI work, but what Meta previously disclosed confirms that Meta downloaded and copied a dataset of text without authorization of the registered copyright owners, including plaintiff, called The Pile, all in caps, as part of its work in training and developing its LLMs. The Pile is an 800 gigabyte open source dataset created for training large language models that is and was well known to AI developers. At the time Meta downloaded the Pile, it was hosted and made publicly available by a nonprofit called Eleuther AI. As described by its creators, the Pile is constructed from 22 diverse, high-quality subsets, many of which derived from academic and professional sources. Models trained on the Pile improve significantly over raw CC and CC100 on all components of the Pile, which improving performance on downstream evaluations. That's, I'll put a little sick there, SIC, because that's their grammar. One of the Pile's architects is an independent developer named Sean Presser. Presser created a dataset in the Pile called Books 3, which is a trove of pirated books. Presser described how he created Books 3 in a Twitter thread from October 2020. Here we have the screenshot, and this is the quote from the Sean Presser. Suppose you wanted to train a world-class GPT model just like OpenAI. How? You have no idea. Now you do. Now everyone does. Presenting Books 3, aka all of Bibliotic. 196,640 books in plain text document, reliable direct download, 4 years. That's a lot of books. Presser explained he created Books 3 in response to OpenAI's papers on GPT-2 and 3, which references datasets named Books 1 and Books 2, the latter of which Presser suspects might be all of LibGen. LibGen refers to Library Genesis, a website offering pirated books that was ordered to shut down for copyright infringement, and we can see the case here. Elsevier Inc. et al. v. sci-hub.org et al. If anybody wants to look that up. If you're interested in hearing more about that, I can cover that in the channel as well. Just make sure to leave a comment about that. To create a pirated book dataset comparable to what he suspected OpenAI created for itself, Presser announced that Books 3 was a direct download of all 196,640 books from a different pirated website called Bibliotic. Or Bibliotic. Bibliotic is a notorious pirated collection of pirated books. For years prior to its use as Books 3, Bibliotic was frequently included in roundups of the best and most popular sources for pirated books. Books 3 was a critical part of the Pile. In Eleuther AI's paper on the Pile, it explained the key value of Books 3 as training material. Books 3 is a data set of books derived from a copy of the contents of the Bibliotic private tracker. Bibliotic consists of a mix of fiction and non-fiction books, and it is almost an order of magnitude larger than our next largest data book set, Book Corpus 2. We included Bibliotic because books are invaluable for long-range context modeling research and coherent storytelling. Presser and Eleuther AI repeatedly and publicly acknowledged that the Pile and Books 3 was a cache of pirated material. Eleuther AI's paper on the Pile noted that there is little acknowledgement of the fact that the processing and distribution of data owned by others may also be a violation of copyright law. Furthermore, the Pile's dataset sheet notes that Books 3 is almost entirely composed of copyrighted works. Presser, for his part, admitted to releasing Books 3 despite fear of copyright backlash. Alright, so that's not something that you want to see as something that you used, something that you incorporated into your work, right? If you're Meta, you don't want pressure. You don't want the person who released it to say that they're doing it despite fear of copyright backlash, and doing it knowing that it is entirely comprised of copyrighted works. Even if only almost entirely comprised of copyrighted works, it's not a good start for your software development here. In August 2023, Books 3 was removed for the most official copy of the pile, hosted by The Eye, an online repository of training datasets, due to copyright complaints. Despite this removal, the original version appears otherwise available as part of the pile from other sources. In its February 27, 2023 research paper, Meta admitted to downloading and reproducing Books 3 willfully as part of its Llama development project. Meta AI researchers explained that the training data used to develop Llama 1 included 2 book corpora, the Gutenberg project, which contains books that are in the public domain, and the Books 3 section of the pile, a publicly available dataset for training large language models. So, for those who don't know, the Gutenberg project, public domain, they're doing some really powerful work over there. They've been doing it for a long time. They've got hundreds of thousands of books, I believe, available, and tons of different formats. And I encourage you to check them out. They're doing things the right way because their books are in the public domain. And the pile is kind of the dark version of that. It's people accumulating all of this information in text format and making it available, but it's copyrighted. That's the difference between those two. It's the public domain versus copyrighted materials that they would need licenses for. In referring to the Books 3 dataset it used, Meta researchers, 1, directly cited the 2020 Eleuther AI paper, which describes Books 3 as a dataset of books derived from a copy of the contents of the bibliotic private tracker, and 2, distinguished between the public domain books in the Gutenberg dataset and the publicly available books in the Books 3 dataset. Meta knew Books 3 was a trove of copyrighted content sourced from pirated websites like Bibliotic and used it anyway. This is what I was just talking about, difference between these two things. Notably, in an earlier research paper authored by Meta AI in June 2022, titled OPT, Open Pre-trained Transformer Language Models, Meta indicated that it had eliminated many of the piled component datasets from its LLM pre-training data because Meta found they increased the risk of instabilities or were otherwise deemed unsuitable. For the purposes of the work memorialized in this June 2022 research paper, Meta excised component datasets that included copyrighted material, excised removed. For example, Meta excluded the PubMed Central and Phil Papers datasets. PubMed Central is a repository for biomedical articles run by the USA National Center for Biotechnology Information, NCBI, and the PubMed Central dataset contains copyrighted material. Likewise, the Phil Papers dataset is a repository of open access philosophy publications from an international database maintained by the Center for Digital Philosophy at the University of Western Ontario. It also contains copyrighted material. In June 2022, Meta also excluded as unsuitable the Books 3 dataset from its training data. Shortly after that, something changed, and, as noted above, by February 2023, Meta had copied Books 3 and used it to train its LLMs. In March 2023, the Llama 1 language models were leaked to a public internet site and have continued to circulate. Later in March 2023, Meta issued a DMCA takedown notice to a programmer that released a tool to help users download the leaked Llama 1 language models. In the notice, Meta asserted copyright over the large language models in Llama 1. Can't have it both ways, though, Meta. If you can't take copyrighted work and then use it and then also say, by the way, we're using this infringing work, so you can't take it from us now. In July of 2023, after Meta was sued for its infringing use of copyrighted material for LLM training, Meta released Llama 2, which it described in a July 19, 2023 research paper entitled Llama 2, Open Foundation and Fine-Tuned Chat Models. The Llama 2 paper does not indicate the specific datasets used for pre-training, but indicates that more data was used, not less, and again conspicuously describes the data it sourced as publicly available online, not public domain. Meta's ongoing exploitation of Books 3 was particularly egregious because it took place after Books 3 was taken down from the pile in 2023 due to copyright complaints directly before Meta sought DMCA removal of the Llama 1 model to vindicate its own copyrights. This is especially ironic considering Llama 1 is a commercial LLM that was developed without authorization on pirated copies of hundreds of thousands of copyrighted literary works, including the literary works of the plaintiff. This is what I was just saying. You can't have it both ways. Say one thing, turn around and say the opposite. Or say it to another person anyway. Instead of willfully downloading and reproducing a notorious tribe of pirated material, Meta could have lawfully purchased copies of books, then negotiated a license to reproduce them. Alas, Meta did not even bother to pay the purchase price for the books it illegally downloaded, let alone to obtain a license for their reproduction, saying they did not buy one copy of this book, let alone ask if they could use the copies in their LLM. Meta's commercial copying of plaintiff's work and works owned by the proposed class was manifestly unfair use for several reasons. Many AI companies have described the AI training process as teaching a model human language much in the way that a human learns. While this self-serving anthropomorphizing of LLMs is misplaced, at a minimum, humans who learn from books buy them, borrow them from libraries that buy them, or otherwise procure them lawfully, thus providing at least some measure of compensation to authors and creators. Meta does not, and it has usurped authors' content for the purpose of creating a machine built to generate the very type of content for which authors would usually be paid. Meta, in taking authors' work without compensation, has deprived authors of book sales and licensing revenues. Here we see the first hints of damages. There is and has been an established market for the sale of books and ebooks, yet Meta ignored it and chose to scrape a massive corpus of copyrighted books from the internet without even paying for an initial copy. Meta has also usurped a licensing market for copyright owners. In the last 2 years, a thriving licensing market for copyrighted training data has developed. AI companies have paid hundreds of millions of dollars to obtain licenses to reproduce high-quality copyrighted material for LLM training. Meta chose to use plaintiffs' works and the works owned by the proposed class free of charge, and in doing so has harmed the market for the copyrighted works by depriving them of book sales and licensing revenue. There we go, that's the damages. So, commercial gain. Meta pirated material for commercial gain at the expense of authors. Perversely, LLMs seriously threaten the livelihood of the same authors whose works they are non-consensually trained on. Goldman Sachs estimates that generative AI could replace 300 million full-time jobs in the near future, or 1/4 of labor currently performed in the United States and Europe. Already, writers report losing income from copywriting, journalism, and online content writing, which are critical sources of income for book authors. For example, the Authors Guild, the oldest professional organization in the U.S. representing writers and authors, and on the forefront of efforts to shore up creative markets against disruptions from generative AI, has published an earnings study that shows a median writing-related income for full-time authors of just over $20,000, and that full-time traditional authors earn only half of that from their books. The rest comes from activities like content writing, work that itself is starting to dry up as a result of generative AI systems trained on those writers' works without compensation. Meta exploited plaintiffs' copyrighted works. Plaintiff and class members have suffered identical harms from Meta's infringement. The contents of the datasets that Meta used to train its LLMs are peculiarly within its knowledge, such that plaintiff is unable to discern those contexts with perfect accuracy. But Meta has admitted to using Books 3 during the relevant time, and the contents of Books 3 is widely reported. Plaintiff makes specific allegations of infringement below based on what is known about Meta's practices and what is known about the contents, uses, and availability of pirated book repositories that it is suspected Meta used, like Bibliotic. Plaintiff Chris Farnsworth, here we go. This is quite a bit. All right, so just to stop for a second here. We're on paragraph 54. We're at the top of page 12 of this, and we're just now talking about the plaintiff. We're talking about what the plaintiff actually did, what the plaintiff actually owns, and we can see they put only one paragraph here. They mentioned throughout that this is an author, right, in books, who has written books, presumably in Books 3. That's why they're bringing this up as a representative of the whole class. So here's paragraph 54. Plaintiff Christopher Farnsworth is the author of a number of books, including Blood Oath, Flash Mob, a novel, The Eternal World, a novel, and The President's Vampire. Nice. Each of these works was and is a part of the book's 3 dataset. Pirated copies of these works are available online through websites like LibGen and Bibliotic. Farnsworth is the author and owner of the registered copyrights listed under his name in Exhibit A. So this is kind of a different approach to what Lehrman was doing, where they wanted to spell out clearly, we have these rights, and probably more because they just got the rights registered. They had the rights, but they didn't get the registration. Here, they put this down into Exhibit A, and we'll get down to Exhibit A. I don't know that there will be actually that much there. We're only seeing 4 books here that he's written. But we'll see what he says here. And as far as the class allegations, we'll just skim through this a little bit here, because we already they've been hinting the whole time of what the class has in common with the plaintiff here. The class consists of at least thousands of authors and copyright holders, and thus is so numerous that joinder of all members is impractical. The claims asserted by plaintiff are typical claims of the class. These are all class action requirements in order to, again, get the court to certify this as a class. It does seem like everyone in Books 3 would be affected in the same way. This action is appropriate as a class action because of common questions of law and fact. The common factual questions giving rise to common answers that move this litigation forward include whether Meta's reproduction of the class's copyrighted works constituted copyright infringement, whether Meta's reproduction of the class's copyrighted works harmed class members, and whether class members are entitled to damages, including statutory damages and the amount of statutory damages, and whether Meta's infringement was willful. So these are all, they're saying, these questions, every author who has any copyrighted material in Books 3 that Meta used, remember, copyrighted materials that they used without permission, without licensing, that's the class that they're defining here. And that seems like a pretty succinct class, easily ascertainable class, potentially, if they can get this information from Meta in the discovery stage here. So let's look at what they actually want. We're talking about the claim for relief here. Plaintiff and the members of the proposed class have created literary works that are original and fixed in a tangible medium of expression, that is copyrightable there, and they own the registered copyrights in the works that Meta reproduced and appropriated for its artificial intelligence projects. Plaintiff and members of the proposed class therefore hold exclusive rights, including reproduction and distribution, under the Copyright Act, Section 106. Meta infringed the exclusive rights under Section 106 of the Copyright Act of plaintiff and members of the proposed class by, among other things, reproducing and distributing the works owned by the plaintiff and the proposed class. Here we go. Prayer for relief. Wherefore, this is what I was looking for. Wherefore, plaintiff seeks that this matter be certified as a class action, and that his attorneys be appointed class counsel, and that he be appointed a class representative. This is all standard stuff for a class action here. Then, what they actually want, plaintiff demands judgment against defendant as follows: awarding plaintiff and the proposed class statutory damages or actual damages at their election, including restitution and disgorgement of profits. That's what we were seeing them talk about earlier, is they've profited off of this. They're going to ask for the money. Attorneys' fees and costs, and any other relief that may be permitted by law or equity to pursuant to the claims for relief. Number 2, permanently enjoining Meta from engaging in the infringing conduct alleged herein, awarding the plaintiff and the proposed class prejudgment and post-judgment interest pursuant to the claims relief, awarding plaintiff and the proposed class costs, expenses, and attorney's fees, and here we go, further relief as the court may deem just and proper under the circumstances. So one thing they mentioned earlier a little bit, just to wrap this up, is the idea of willfulness. This is something that they're actually asking as part of the class certification. They're saying this is a question that they will have in common, that whether Meta's infringement was willful is something that will affect how much relief they'll be able to get here. If it is willful infringement, then, and it certainly seems like they're making a case for it here, then Meta is going to be in a little bit worse of a position than if they had, well, one, done the right thing, but two, done less of the wrong thing, so to speak. So, jumping back up to the top here. Oh, actually, sorry, we should get to that Exhibit A, which is not attached. Exhibit A was probably filed separately. We might not be able to see that, but that is all right. So here we were, U.S. District Court, Northern District of California, Christopher Farnsworth v. Meta Platforms, Inc. Again filed last week. We have October 1, 2024, and I'm here today, October 7th, 2024. Thank you for joining me on the stream. If you enjoyed it, please like and subscribe. And if you have any other cases you would like me to cover, please mention those in the comments below. I will try to get out within the next week or so a shortened version of this so that people who don't have all of the time in the world, I know people are busy, to watch this me read through the whole case will be able to enjoy it as well.